So, thank you for being with us here at Bar and Bench's interview series with the Advocate Generals of India. And this has been a very eventful year for the state of Karnataka, whether it be the legal cases or the laws being passed. First, we will try to understand, sir, why did you choose law as a career?
Well, of course, my father was a judge, but ironically, he did not want me to do law. He, in fact, wanted me to be a doctor, and he actually persuaded me to join a medical college. But somehow I was always fancied, right from my childhood days, possibly somewhere subconsciously being influenced by my father's tenure, first as a lawyer and then after the judge. That seems to be the obvious choice. But my interest in political science and law was always there in my university days. That you could say, possibly, the overwhelming presence of father in the profession possibly made me take up the choice of the profession.
So did you always have
study law?
Did you always have legal discussions, etc., at your house when you were growing up, and let's say in your teenage years, etc.?
No, actually, no. Okay. We did not have much, but the fact of the matter is, growing up in the family of a judge, even without there being discussion, you are bound to observe these aspects. And it was so much part of our family. Lawyers coming in, judges coming in, we visiting some of the judges. So therefore, you could say that though there were no formal discussion about these things, but the observation was always.
We have always seen that whenever a party in power changes at the state, the Advocate Generals are the first who tenders their resignation. I wanted to understand, why is it so? Shouldn't the post of the Advocate General go over and above who is in party in power, unless the dispensation so requires that new Advocate General be stepping into the role?
I would say if you trace back the history of the post of Advocate General, there was at one point of time a suggestion that the law minister of the country should be appointed as Attorney General, and the law minister of a state must be appointed as the Advocate General. But then it was turned down, saying that no, we require a law officer, first law officer of the state or the central government for that matter, who should not only be apolitical but independent. Therefore, the post of Advocate General was created. But to answer your question as to whether the post must continue without any interruption, I think there is no requirement that the Advocate General should resign immediately after the political dispensation changes. But the highest traditions have always marked that because he is the choice of the government of the day, it is the government of the day who chooses the Advocate General. The highest traditions have been till today that as and when the government changes or the chief minister tenders the Advocate General does so. I don't see anything wrong in that, because ultimately, as a matter of fact, it is the policies and the decisions of the government of that day which are invariably called into question before the courts. And the Advocate General, being the first law officer of the state, is not only bound to defend those decisions, but also to advise the government appropriately. Right? And in our political spectrum, it is but natural that one political dispensation may take a diametrically opposite view of the previous one. Therefore, if the Advocate General appointed by previous dispensation is to continue, then he may land up in a position where he may have to oppose the decision taken by the previous regime. In order to avoid this kind of embarrassing and conflicting situations, I think there is nothing wrong if the Advocate General also is appointed afresh by the successive political dispensation.
So, you are one of the most rare advocates or advocate generals who have started this law clerkship program at their office where you invite applications from all across India. My single point question to you is when you select candidates for this law clerkship, do you look beyond the tier A or tier 1 law schools and also to those law schools like tier B, C, D who are usually underrepresented?
I'm glad you asked this question because when I took over the office of the Advocate General, I found that we did not have law clerkship. In fact, most of the high courts, that is judges, have this concept. Therefore, we started this. Now, the system of recruitment of this law clerks is we throw open applications for all over the country. And we recruit about 5 law clerks at a time who run in for 1 year of tenure. And there's no restriction of any schools. I would not say, but all those persons whom we find suitable, who would possibly be effectively assisting us, are picked up. And there is nothing like we pick up from tier B cities or tier C cities. Some of the best are taken in the office.
So, as per the National Crime Records Bureau, sedition cases in the state of Karnataka were about 22 in the year 2019, which, according to some other private research portals, which I don't want to quote here because they are not really reliable, that went up to 53 in 2021 2022. My question to you is, irrespective of what the Supreme Court had ordered now, what is your take on the law of sedition? Is it needed in the statute book today? As a senior member of the bar, your legal opinion on the subject?
I would only say this much: the act is fighting for the Supreme Court of India and some all this passed. It would be inappropriate for me to say anything. But the fact of the matter is, it was a requirement and it's there this time.
It is very rare for an advocate general to quote a Bollywood song during the closure of arguments, especially so in such a sensitive case, which is what was happening in the Karnataka High Court during the hijab case hearing. Given the song you quoted, the lyrics went like "Na mo chupa ke jiyo or na sar jhuka ke jiyo, gamo ka daur bhi aaye to muskura ke jiyo." That time we couldn't ask you this, but what was the message that you sought to give with these lyrics?
Don't you think the reading of that itself sends a strong message, irrespective of what the case we were arguing? It does say that we have all been taught to lift our heads high and live. And finally, it says that gum ka daur aaye to bhi sir utha kar. I don't think it requires any further explanation.
My candid
But
question
another explanation, number one. Number two, see, these are all matters in the courts. You use these things. They are not substantial arguments or legal submissions based foundation of which is based on this. Right. The passing remarks of some advocates use these things, some advocates use illustrations. They are passed off just the courts also sometimes admires it. The courts also pass these remarks. These are nothing which must be taken, I would say, very seriously in terms of legal submissions.
There are so many judgments of the Supreme Court which are cited lyrics while they start.
Therefore, these things, you require these interludes in between serious legal submissions sometimes.
How do you differentiate? No, I'm not entering into any of the controversies, but how do you differentiate between a turban and a hijab when we're talking about uniforms in schools or colleges?
See, insofar as this hijab case is itself was concerned, the stand the state government took was that the prescription of an uniform is a right to be prescribed by the college management. This is what the state government, the state government did not go into this question. All that the state government said was, it is for the institution concerned to prescribe what would be the uniform. Now, every institution has their own way of prescribing it, looking at the local conditions, the kind of students there, and what would be uniform, what would not amount to uniform. Therefore, they have prescribed certain rules, regulations. If any student does not does not come within that ambit of those things are private. Distinction does not. All that things. So the state government is concerned, it did not say anything about any turban or hijab. All that we said is for the institution. So long as the students, met the requirements of the institutional prescription, they were allowed.
In case of land encroachments or illegal constructions, how important is the concept of fair hearing to a party? When I am not getting into the bulldozer politics, which is getting headlines now, I just wanted to understand from you, as the principles of natural justice, is the concept of fair hearing important when such matters are at stake?
So, see, these matters, they cannot be put into a straight jacket formula. Okay. In which situations you have got to give hearing, in which situations you do not give the right hearing. We have the concept of post-decisional hearing. We can have the concept of pre-decisional hearing. Okay. We have the concept of to understand what is the nature of occupation. Okay. Is it an occupation for a prolonged period by which some right has accrued? Or is it an illegal occupation? Okay. So these are all matters which we can't put in straight jacket formula by saying one or other. Depending on the facts and circumstances of the case, principles of natural justice require. Yeah. Okay. So I wouldn't straight away answer by saying yes, in this case hearing should have been given, or in this case hearing should not have. Let us say building is illegally constructed. Somebody is illegally occupied, and they have no right to occupy the same. It will be perfectly entitled for the state to reclaim the property by taking possession of this.
Right. So, do you echo other demands being
For
made?
instance, under the Land Acquisition Act, under the right to file you have emergency provisions for taking over a particular property.
Right.
Without hearing. And the concept of post-decisional hearing has been evolved with Supreme Court. It's not for the first time anybody is taking over. We have, there is a fine distinction made in the judgment of the Karnataka High Court where they make a distinction between what is considered as illegal occupation per se, which they say principles of natural justice would not be applicable, or occupation without the authority over a prolonged period of time. So these concepts which have been evolved under the administrative law can must be applied depending on the facts of each case.
So, what is your take? Do you see there is a demand of having zonal benches of the Supreme Court in the South, and would it increase the access to justice?
No, since now I represent the government, it's inappropriate. It's a matter of policy of the government to be inappropriate on my part to say, okay, view on that. Everybody can have different views. I myself may have a view. But as an advocate general, I don't think it would be appropriate on my part to voice any opinion as to whether there must be benches of the Honorable Supreme.
Also, maybe due to the advent of the virtual courts, the barriers are slowly reducing.
No, I don't think so. That should be the issue. The question is about the integrity of the institution, basically. And it is not so simple to suddenly say that we should have benches or the regional benches, etc. Several factors go into this aspect. The Constitution as it stands today of the Supreme Court is that the matter of policy which requires contemplation and understanding.
Right.
But it is a fact, I must tell you, that there has been a demand. In fact, there has been a huge demand for establishment of bench in southern region.
So, what is your take on the PIL jurisdiction, both of the Supreme Court and the High Court? How can the bench read out frivolous petitions from the ones which we indeed, make a difference? When Justice P.N. Bhagwati ushered in the concept, the thought was very different than from what is happening every day at the top court today. Judges are almost tired entertaining frivolous petitions. So, is there a way out?
No, now the Honorable Supreme Court itself has a number of decisions involve this jurisprudence as to what are the kinds of petitions which requires to be entertained as public interest litigations. There's a publicity interest litigations, philosophy interest litigations, politically motivated interest litigations must not be admitted. As you rightly pointed out, the theory of Justice Bhagwati that persons, fundamental principles were persons who are unable to have access to justice, either on account of they being economically weak or because of their illiteracy, or they are placed in such a position in life where they were not in a position to approach the courts of justice. Someone else can ventilate their grievance. This was how traditionally the theory of public interest litigation worked. But however, later on we have seen the court, the honorable courts extended this also to review policy decisions of the governments, arbitrary actions of the police people, arbitrary actions of the executive, to see as to whether they conform with law or not. But the courts, I must say, have always maintained this balance to see whether in the garb of public interest litigation, is it someone else's policies or someone else's grievances are being ventilated, or some other things are addressed. Courts always examine. And such a situation, courts have dismissed these petitions with exemplary process. There have been such instances I have seen. But that is something which the courts have a very, very delicate balance to be brought about between these things.
This is a connected question, sir. There are a lot of cases that are coming up in the courts today wherein a certain individual is suffering, right? But a community is approaching the court on behalf of those individuals, or might as well be, say, organization. The individuals are not represented in the court, so as some lawyers contend. The Solicitor General of India, Tushar Mehta, has time and again contended that such individuals or such organizations do not have the locus standi. Is there a way in which such petitions should not be entertained?
I would straight away answer this by saying that we should go back to the original theory of public interest litigation. Unless it is shown that here are a group of persons who are unable to seek access to justice on account of, I told you, those considerations, there is no reason for someone else to come. If somebody is in the traditional theory of, I will say, a violation of fundamental rights, is the person who alleges violation of fundamental rights must come forward.
Right.
How does it prescribe? And today, see, you have the access to a jurisdiction under Article 226 or 32 is not so difficult. It's not so difficult so that someone else comes. Anybody can just go and engage a lawyer. We have a legal services authority. We have free legal aid services authority. I think prevents a person from going and approaching and saying, this is the aspect. But no. We have on the contra, I have a number of these organizations who come about saying that we ventilate the grievances of someone else, which I don't think must be.
Is there a possibility of a stringent preventive action in cases of hate speech, and do you think it is becoming a little community specific these days?
This is a sufficient safeguard now law.
Do you think that's safeguard?
It's there, it requires to be enforced.
But the majority of litigation that is coming up each passing day concerns some or the other hate speech. Do you think it is becoming community specific at some instance? Because hate speech, as envisioned by in the United Kingdom or the United States of America, was very different than what we are witnessing here today. Whether it be,
I think the existing legal framework we have is sufficient to take.
So, as an Advocate General, are you always taken on board by drafting laws and ordinances?
You do seek the ordinance.
Okay. So, my one question to you is that what was the need of bringing in the anti-conversion bill?
That's a question you should ask somewhere else, not to.
But I'm sure you would want to take it into confidence.
That's around matters of policy.
Okay. Okay. I mean,
obviously, government will answer.
Sir, did you ever face any moral dilemma as an AG when you advise the government? There are instances when you wish you advise the government differently and the government is on, however, another tangent, so as to say, and they believe on in something else. So how do you balance such a situation?
There is no conflict. There is no conflict. As a lawyer, also you experience.
Right.
It's not very moral dilemma or anything like that. We always consult, come to some conclusions.
Okay.
We always have differences. Need not be. We need not have differences.
Okay.
I have not faced.
So, what is your comment?
I have not faced any moral dilemma with the government on any issue.
Till now?
Yeah, till now.
The Chief Justice of India, N.V. Ramana, had commented that on the Republic Day function that laws are being rushed through the Parliament, and that is not a good practice. What is your take on this?
I feel sufficient deliberations take place.
It does. So, there is no
From
question.
whatever I have seen, from Karnataka Legislative Assembly, whatever little bit I have seen, sufficient deliberations will take place. Okay. It's without reference to the remark you have made about the Honorable Chief Justice. I'm not saying anything about that. But my little experience of watching assembly proceedings, a large number of debates,
Someone
whatever
asked.
little bit I have seen.
Someone
Again,
asked.
this is without reference to the remark of the Honorable Chief Justice.
No, that is taken from.
So, as an Advocate General of the State of Karnataka, do you miss just being a senior advocate?
And the life of that.
I'll answer this by saying this. हर किसी को मुकम्मल जहां नहीं मिलता, किसी को आसमां तो किसी को जमीन नहीं. Thank you so much.
Subscribe to our YouTube channel and click the bell icon.